Good afternoon. I'm Catherine Saldana, one of the mentor attorneys with the Dallas Volunteer Attorney Program. Thank you for joining us today. I'd like to tell you just briefly, of course, the Dallas Volunteer Attorney Program is a joint venture between the Dallas Bar Association and Legal Aid of Northwest Texas. We partner our low-income clients with attorneys willing to do the work as pro bono attorneys. A few benefits of doing pro bono work through DVAT is that we're a safety net. We provide forums, mentoring, and training, and such as today's CLE, and we have support staff that conducts a good part of the legwork before we actually assign the case to an attorney. DVAT mentors review pleadings prior to filing and propose decrees, orders prior to proving up. And of course, there's malpractice coverage that we offer. I am pleased today to introduce Jack Wilburn. He's one of our favorite attorneys who has mentored Kristen Salas and me, who are both the mentors with DVAT for years and years. And there's never a time when he can't help us. He always has a solution to the questions. Jack is a sole practitioner in Carrollton. He practices in Dallas County and the surrounding counties. His area of practice is probate, guardianship, and estate planning. He regularly serves as an administrator or guardian in the local courts. His education was Bachelor of Music Education from McMurray University in Abilene, and also received his JD from the University of Houston. He's proud to be a former intern for Judge Nikki DeShazo in Dallas County Probate Court and Judge Russell Austin in Harris County Probate Court 1. He was a past chair of the Dallas Bar Association Probate Section. He's a favorite DVAT mentor and regularly speaks at our DVAT CLEs. He lives in Prosper with his wife, Amy, and their two children, Caroline and Carter. I'll let you take over, Jack.
Thank you, Catherine. I appreciate that. All right, welcome everybody. Bear with me while I get my presentation up and running. It's always an adventure when I am in charge of the technology. Let's see here. But while I'm doing that, I think I can talk and do this at the same time. We will see. Usually, you know, I start with a joke. And I'd like to say this is a joke. I don't know whether to laugh or cry, but here's the joke. The Dallas Cowboys. Thank you. Thank you very much. That was the best joke I've ever told. Or here's my other joke. Jerry Jones as a GM in the NFL. Maybe it's too soon. Maybe the wounds are a little fresh from our, I'd like to say it was a game that we played on Sunday, but it was not good. So I'm just rambling because for some reason I cannot get, there it is. Hello. There we go. A broken clock is right twice a day. There we go. All right, so you're here to learn about what to do when someone dies without a will. If you've seen this presentation before, it's gone by many other names, the most popular of which is the probate plumber. That name has officially been retired, mainly because when I go to the courthouse, everybody just calls me the plumber now. I don't know if that's because of the presentation or because my pants are sagging and I have a plumber crack. But anyway, all right. So one of the first questions is, how often does it happen that someone dies without a will? You know, everybody has a will, right? No, 70% of people die without a will. That's what some reports tell us. I know we're all out there doing our part. We're doing as much estate planning as we can. DVAP has estate planning clinics. But in spite of that, 70% of people die without a will. And this, I cannot figure out a demographic broad brush to paint here about intestacy. Rich people, poor people, sophisticated people, unsophisticated people, single people, married people. It doesn't seem to matter. And sometimes I'll have clients come in and I am absolutely shocked when they tell me that their spouse died without a will. And it is, but it's not the end of the world. You just have to know how to deal with it, and what to do in response to that. So a client comes in and you're doing your intake. They're telling you that their loved one or friend or whoever has passed away, and they're telling you about the assets, and the inevitable question comes up, oh, did they have a will? And they say no. What do we do now? Most importantly, just keep talking to them, because the more information you can gather about the situation, the better you're going to be able to help. I will say this, just because somebody dies with a will doesn't necessarily mean that you have to probate that will. So you want to gather as much information as you can about the assets of the decedent and the nature of those assets. What did they have, and how were they held? And is there any way that asset's going to pass outside of the probate process? So just like I said, just keep asking questions. There are no dumb questions. You can't go wrong asking too many questions. So ask what the decedent had, what the assets were, and how they were held. Because it's possible that all of the assets that are in this, that belong to this decedent, are non-probate assets, and you wouldn't need to go to probate even if there was a will. So examples of that, as most of you already know, are, anything with a payable on death provision, anything with a beneficiary designation, life insurance policies that name people that are still alive, bank accounts with payable on death, joint tenants with right of survivorship accounts, financial accounts at brokerage houses with beneficiary designations, or even, and I learned this the hard way one time, sometimes the company retirement accounts have their own contractual intestacy provisions built into them, and they don't care what the laws of intestacy say. So they will already say, hey, if someone dies, here's how this asset is going to be divided if the person did not leave a beneficiary listed, or if a beneficiary predeceased. So look into those things as well, because there are more options than you can think of, or may even be aware of, for how assets can pay out upon someone's death that don't involve going to the courthouse. Just as a reminder, trust assets are non-probate. So if someone created a trust and actually funded it, I look forward to the day a client comes in and has a trust and it's actually fully funded. I've heard stories that sort of thing happens, but I've never had somebody come in with a trust and it actually be fully funded. And there's always something that was left out of it that's going to involve doing something. But maybe you're lucky and your client has a trust that's fully funded. Well, there's no need to probate for that. Like I said, bank accounts, joint tenants with right of survivorship, payable on death provisions, beneficiary designations, the retirement accounts and IRAs, again, beneficiary designations, and like I said, the terms of the contract, and even vehicles. There is a transfer on death line on a vehicle title. I've never actually seen one of those filled out, but it's there. And one of these days, hopefully, I will come across a title that's actually had the transfer on death part filled out. Or you can actually also do an affidavit of heirship with the DMV for a car if there isn't a will. So that is also a possibility. So what tools are in your toolbox? So again, just because somebody dies without a will does not mean that all hope is lost. And what are the techniques we use for handling intestacy? So the first thing we want to talk about is the determination of heirship. That's under Texas Estates Code Chapter 202. There's the court-created independent administration, which is under Texas Estates Code 401.003. There's a dependent administration under Texas Estates Codes 306.002 sub 1. There's an affidavit of heirship under 201.053. Let's put a little mental asterisk next to affidavit of heirship. That can be somewhat controversial, and you'll get differing opinions from differing attorneys depending on who you ask about the efficacy or the wisdom of using an affidavit of heirship. There's the small estate affidavit, that's section 205. I am of the opinion that small estate affidavits can be done pro se. I generally just point clients to the form and set them loose on that. I have, generally speaking, it is not a financial benefit for them to pay me to get involved in that. And as I say every time I give this talk, Judge Lincoln Monroe has an amazing paper and has done some amazing CLEs on small estate affidavits. They can be somewhat esoteric and a little more complicated than you would think they would be. But he does a good job of laying that out. And the form in Dallas County, specifically, you'll just follow the directions in affidavit of the small estate affidavit, you'll be fine. And it looks like I have a typo here. Affidavit of heirship is actually 203.001. I was going to say I got all the right numbers in there, but it looks like I can't even claim that. So I don't know where the 201.053 affidavit of heirship's 203.001. Thank you, Judge Monroe, for that correction. I appreciate that. And Judge, if you're there, if you've got a link to your small estate affidavit form, that would be awesome as well. Let's see what else we got. We've got a combination determination of heirship and order of no administration, which is under 451 of the Texas Estates Code. We have something called an application for family allowance and order of no administration, also under 451. And we have an administration of community property under 453. And a fairly new provision, a couple of years old, under 153 is access to an intestate account with a financial institution. So let's take those one by one. When someone dies without a will, it's important to determine who their heirs are, because as you know, in a will, you can leave your assets to anybody. You don't have to leave it to your heirs. You can leave it to a friend, to a neighbor, to a charity. It doesn't matter who your heirs are. For the most part, you just name who you want your stuff to go to. But when you are intestate without a will, we're going to have the court determine who your heirs are, and that's going to be done under 202 of the Estates Code. When you file a determination of heirship, you're going to have an attorney ad litem appointed. This says $500. I believe that's gone up to $600, depending on what county you're in. But no matter what, as far as I know, as of today in Collin County, you don't have to prepay an ad litem fee. As everybody knows, things are about to change in Collin County. So just be aware of upcoming changes there. But as of right now, as far as I'm concerned, you have to pay, you have to prepay in Dallas and Denton. I don't know anything about Tarrant County because I don't practice there, but in Dallas, you have to prepay your ad litem fee before you can get your ad litem appointed, and you can't do anything with your airship until the ad litem is appointed. Let's see here. You have to have 2 disinterested witnesses testify regarding the airship of your decedent. And I understand that sometimes this can be difficult, but they need to have personal knowledge. And I'm going to call a quick timeout. If you're watching the Q&A or the comments, Judge Monroe has just given a link to his small estate affidavit paper and the requirements. So make a note of that and save that for future use. That is an invaluable asset either to you or your clients. But thank you for that, Judge Monroe. Hopefully y'all haven't learned this the hard way as I have. Sometimes you're just stuck with the witnesses that you can come up with, and they don't always have personal knowledge of what they're testifying to. And you can end up in a situation where that testimony doesn't get you there, and the judge will not sign your judgment on airship. My pro tip in that situation is, if you can't find witnesses and your client doesn't have anybody, then you may have to hire a forensic genealogist to go out and do a report, and then that genealogist will come and testify for you as to the contents of the report. And in my experience, generally speaking, between the expert testimony of the genealogist and the attorney ad litem, essentially verifying that information, that can get you there if you don't have good witnesses. So that's my tip on that. When you file the determination of airship, you have to have citation on all of the alleged heirs, or you have to get waivers from them. And so it's faster if you get the waivers instead of having to have the citation issued and then send them out and wait for the green card to come back and all of that. But nevertheless, either way, you're going to have to notify the heirs. I've actually had clients say, well, I don't really want to notify them. Sorry, bro. We have to let the heirs know that they are heirs and that they are entitled to notice of that. So you're not going to get to a hearing without that. So before we move on to court created, let me back up just a sec. You also have to file an attorney affidavit that says you gave that notice to the heirs before you can get to a hearing. And that'll just show the court that you've jumped through all the hoops that are required. You also have to do published citation. In Dallas County, that's in the Daily Commercial Record. And you won't get anything done until you pay for the citation. So watch for that bill and pay that, and pay your ad litem fee. Most of the time, when I see the message boards on Facebook or on the emails from other lawyers complaining about their case not moving forward, 9 times out of 10, the answer is, well, did you pay your ad litem deposit, and did you pay for your posted citation? Because without that, you're not moving forward. But once those are done, you're good to go. And the thing I like about the determination of airship is it is a judicial determination. It is, and we'll talk about this some more about the affidavit of airship. It is, it's pretty solid. It's been issued by a court. It's been verified by an ad litem representing unknown heirs. It's about as solid as we can get when someone dies without a will, which is one of the criticisms of an affidavit of airship. But we'll talk about that. We also have court-created independent administration. So this generally goes hand in hand with the determination of heirship. A independent administration requires the agreement of all of the heirs. Well, you can't say who the heirs are until the court has determined them. So you generally have to do both of these things together. I am not aware of any court that will give you a court-created independent administration without the accompanying determination of heirship to prove who the heirs are. Sorry, I'm having some technical difficulties here. The way that the heirs show their agreement is through what's called a designation, consent, and waiver. That's signed in front of a notary. Just a little pro tip. In your form for your designation, consent, and waiver, regardless of if this is a specific fact for your case, you should have language in there regarding the sale of real property. If you have a house in an estate, in an intestate estate, and you're ever going to want to sell it, you're going to want to have the independent administrator have the power of sale. You're going to want to get that in the order appointing them. And the way you do that is to have all of the heirs agree to that in their designation. So I just keep it in my form, regardless of if it's something that's coming up in that case or not. Let's see, I'm just looking at Q&A so I can keep up. All right, so and like I said, most courts require a simultaneous determination of heirship with their independent administration. You can also have your heirs waive bond for the independent administrator, which is super helpful. It gets really convoluted, and I know that there are times when the court requires bond of an independent administrator, but it just gets a little funky trying to deal with the logistics of that. And it also requires the closing of your independent. I don't generally close my independent administrations, but in order to get rid of the bond, you got to file a closing affidavit and close your administration. So it just adds another layer. So I like to ask that my heirs waive bond. Here's the thing, if they're not willing to waive bond, they probably aren't willing to have someone serve as independent. So just go dependent. And we'll talk about that in a minute. Now, this, I believe this to be true, again, as of today. In Collin County, I do believe you can get an independent administration when there's a minor heir. I am certain that you cannot get an independent administration in Dallas or Collin County when there's a minor heir. That's just based on my personal experience and talking to other lawyers and talking to judges. In Dallas and Denton, they just don't do it. Judge Copeland has historically done it, but again, you're going to get sick of hearing me say this. Right now, Collin County is an unknown in the future. We just don't know what that court is going to look like. We don't know how the requirements are going to go. I suspect there's going to be a lot of how to practice in Collin County presentations given over the next year or so as we figure that out. So if the client comes in and they've got a minor heir, just go ahead and tee up dependent, and we'll talk about that just in a minute. The downs, your client might ask, well, why do I care if it's independent or dependent? As you all know, an independent is quicker, it's cheaper, it doesn't require the administrator to come back and ask permission or to do things for the most part. It doesn't require annual or final accountings for the most part. But that means it doesn't offer as much protection for the heirs. So, you know, assuming somebody's a grown-up and they're willing to sign a designation, great. But sometimes I think people sign things and don't really think it through, and or have an understanding of what rights they're giving up or what protections they're giving up when they agree to an independent. But it is less expensive to do an independent administration, and it can be faster, just because you're not having to go to court and set hearings and deal with those sorts of things. So it is a very popular choice if you've, especially when you've got a family where it's a surviving spouse and she's the sole heir. Then, you know, why not have her agree to have herself serve as the independent administrator and as the sole heir. So like I said, it can be very cost effective to do this. So now, dependent administration. So it's just like it's just like an independent administration, only different. If your heirs don't agree, if you've got disputes going on and they're already fighting by the time they get to the lawyer's office, you're probably not going to get an independent administration. So I just move on down the road and file my dependent administration and go from there. Your court may require a simultaneous determination of heirship. I think that's becoming more and more common, mainly because it's got to be done, right? You're not going to be able to close your administration and pay out the assets of the estate until you know who the heirs are. So in my experience, a lot of courts are saying, look, I'm not going to do a dependent administrator until I know who the heirs are. And it's done hand in hand, just like the independent with the determination of heirship. It's just a determination of heirship with a dependent administrator being appointed. Same process. A bond is required of a dependent administrator. It is set to the liquid assets. There is no bond requirement for real property. So lots of times, I mean, this happens all the time. A judge will ask, all right, what are the assets that we need to be worried about for the bond? And lots of people start with, well, there's a house worth $1 million. Okay, well, next, because that's not a bondable asset. Now, when that house is sold and it's converted to cash, that is a bondable asset. So you'll need to increase your bond when you sell a piece of property. And then you just add up all the other assets there are: cars, personal property, bank accounts, financial accounts, whatever there is. You just add all that up and you get to your bond amount. In a dependent administration, an annual account is required. Implied in that, I should have a little line in here that says an inventory is required, just like there is in an independent. It's due with the inventory is due within 90 days. I throw that in because you can't do your annual account until you have an approved inventory from which to base that annual account off of. So, but you do have to do an annual account. That does increase cost. It does require a final accounting. That's also one of the reasons that costs for a dependent are increased. And it offers the most protection for heirs because the dependent administrator really can't do anything without court approval. If they want to sell a house, first of all, they have to ask for permission to sell the house, and then they have to get the contract they sign approved and do a report of sale and get a decree of sale. The same thing with personal property. You have to request for authority to sell personal property, and you have to report back to the court on that. You really just can't do anything there was just a comment here that, and I don't know if y'all are following along on the comments or not, but Judge Monroe pointed out that under 401.003, a court cannot appoint an independent administrator until heirs have been determined. Yeah, I don't think, I've been practicing 20 years. I don't think I've ever had a judge even contemplate appointing an independent administrator without the heirs first being determined. But on the dependent administrator, I tell my clients it's like a big game of Mother May I. But the older I get and the younger my clients get, sometimes they don't know what Mother May I is, which is depressing. But you just can't do anything without court permission and court authority, and that on the one hand that drives up cost because that requires more motions and more orders and sometimes more hearings, but that's what provides the most protection for the heirs, and quite frankly the most protection for the administrator as well. Oh, so I guess I'm the only person that can see Judge Monroe's comments or links. I apologize for that. Maybe DVAP can send out the link to Judge Monroe's small estate affidavit paper and forms after we're done here. I apologize for that. Thank you for pointing that out, because I am laboring under a misconception that y'all can see what I can see. So that's the dependent administration. It's very common. If your client isn't qualified, and to be qualified, they have to be over the age of 18 and a resident of the state of Texas, or have filed an appointment of a resident agent. They also have to be a non-felon. You should always ask your clients if they're a felon. Never assume anything about anybody. I don't care. It just goes back to, you can't judge a book by a cover. Little old lady from church, she may be a felon. Always ask. I'll just say that. Always ask if your client is a convicted felon. Because a convicted felon cannot be appointed as an administrator, either independent or dependent. But if your client's not qualified, or the court determines that they're not suitable, they will, for the most part, appoint an independent third party that's a lawyer. If you perceive any issues coming up, sometimes you can try to reach an agreement amongst all the heirs and come to the court with a proposed administrator, but they have a list of people that they are willing and happy to appoint. So if you don't know anybody, or you can't get an agreement, the court will recognize that your person's not qualified or suitable, and they'll just appoint a perfectly great attorney to and hey, on the chat, it looks like Maricela helped us and posted that for everyone. So hopefully, if you can see it under the chat, you can access it there. Thank you for taking care of that for me. So that's dependent administration. The independent administrator and the dependent administrator that are court created are the most common ways you're going to deal with an intestacy situation. The rest of these become increasingly less common. All right, affidavit of heirship. This is not a court proceeding. It is a document that is drafted and signed by disinterested witnesses before a notary, and it's filed in the deed records. It is a it's most commonly used, if I can use proper English for a moment, it's most commonly used when someone everything else is non-probate. And this is a very common situation. A widow comes in, husband has died, and everything had a beneficiary designation. Because think about what most people own. They have bank accounts, they have retirement accounts, they have stock accounts, things like that. And those generally have beneficiary designations. And if they were married or not married and just set the account up this way, it can be joint tenants with right of survivorship on the bank accounts. And all of that passes outside of the probate process. And so we don't have to go to court for that. And we'll get to this in a minute. You can do an affidavit of heirship on vehicles to transfer title to cars. But you've got the house and you're like, dadgummit, do I want to go do a whole probate thing just because there's a house? Well, some people are of the opinion that you can file an affidavit of heirship and show that the surviving spouse is the sole heir of the decedent and that the house should pass to her. It's filed in the deed records and it shows her as the owner. Other people say, and I've seen this on the message boards, affidavits of heirship aren't worth the paper they're written on. The older an affidavit of heirship gets, the better it gets, is my opinion. One thing I ask people is, how quickly are you looking to sell this house? Because I try to start by thinking about what the title company is going to do. And in my experience, title companies, I'm painting with very broad brushes here, so take all of this with a grain of salt. And let me see if I can work any other cliches into that sentence. But anyway, title companies are hesitant to close on affidavits of heirship that are less than a year old. I've been able to get around that with certain title companies. I've lost that battle with certain title companies. So I always just start with, hey, all right, it looks like we've got this down to the only thing we have to worry about is the house. Everything else is non-probate. Are you going anywhere anytime soon? And if the answer is no, I'm going to stay here forever. Great. Let's just do an affidavit of heirship. Let's get it on file. And when you go to sell this house 5, 10, 20 years from now, it'll be there. I will also tell you this. If you do nothing for your client in this regard, the title company will take care of it for you. So if you're really just looking to send a client out without doing anything affirmatively for them that you have to charge them for, and you look at the estate and say, well, it looks like everything's non-probate. You don't need to probate for any of this. You've just got the house. When you go to sell it, the title company will help you with an affidavit of heirship. You'll sign some extra documents at closing and it'll be taken care of. So I think that's really kind of the personal preference of the client. Some people are happy to let it float and deal with it later. Some people want it taken care of now. Some people don't want to deal with any uncertainty regarding an affidavit of heirship, and they send you down and you do a determination of heirship. And we'll touch on that in just a second as well. But this is a great option. But as I've said, it is somewhat, I hate to use the word controversy, but it is not 100% guarantee agreement between all lawyers that this is the way to go. But it's a tool in my toolbox and I use it. So for whatever that's worth. Small estate affidavit. I am not going to spend a lot of time on this. The expert has spoken. You can go to his documents and see what there really is. I just want you to know that it's there. It's something that is filed with the court. It's not for every estate. It's only for estates that have non-exempt assets that are under $75,000. Again, it requires 2 disinterested witnesses. It does not create an administration. All it does is essentially say, hey, if you've got assets, these are the people to pay them to. Based on my experience, some courts will only approve a small estate affidavit where there's no real estate that's involved. Sorry, I didn't mean to click off of that so quickly. But again, not to belabor the point, but there's been much more intelligent papers on this than I can share. I just pointed out as a technique to deal with when someone dies without a will. But again, avail yourself of Judge Monroe's wisdom on this, and you can't go wrong. Like I said, I have, after years of just being beaten over the head because I can't seem to do them right, I just give the pamphlet to clients and like, here you go. Good luck with that, because I end up spending more money than it's worth for them trying to do it for them, and they can do it themselves. So, all right, determination of heirship and order of no administration. Going back to the situation where everything's non-probate but the house, and your client is not comfortable with the affidavit of heirship, you can do this, or you can just file a determination of heirship. But this just says it formalizes what a determination of heirship accomplishes. Oops, sorry, I didn't mean to get off that so quickly. It's discretionary. The court, I've never really had an issue with it. In some courts, you will have to sign what's called an affidavit of no debts, because if there's debts, then there's a necessity for administration. But think of it sort of like the muniment of title of intestacy. If everything lines up just right and there are no unpaid debts, you can use this if a client is a little queasy with the affidavit of heirship. So, all right. Let me see. There we go. Application for family allowance and order of no administration. So under 451, the code provides a procedure for a court to dispense with administration if the decedent is survived by a spouse, minor child, or adult incapacitated child, and the value of the estate, not including the homestead and exempt property, does not exceed the family allowance. Essentially, administration is not necessary because there would be no property for the decedent's creditors or will beneficiaries to reach. So it's not that it's completely upside down and insolvent. There's just the family allowance is going to eat up everything before any creditors are able to get their hands on it. So we're starting to get into the back of the toolbox now. These are things that I use less and less frequently. They just don't come up. The facts don't work for this super often. Your most common tools for an intestacy are the independent administration with determination of heirship, the dependent administration, the affidavit of heirship, and the small estate affidavit. But I just want you to know that these things exist. File this away in the back of your mind, so when you're talking to a client, you're like, wait a minute, I think we may have a solution for this. So there's that. You'd think I'd never given a presentation before. I can't make, there we go. Okay. There's also administration of community property under 453. It permits the surviving spouse to administer the community estate. And this happens with both testate and intestate situations, provided that no personal representative has been appointed. So this would be a very rare situation, or it hasn't come up for me. But somebody actually has a will, but you can avoid probating the will using 453. It's all, you might have heard it called an unqualified community administration. I think of it akin to the community administrator that we use in guardianship sometime. to avoid guardian of the estate when you've got a spouse and community property. So that's something to be aware of. This is kind of cool. You can get access to an intestate decedent's account with a financial institution under Section 153. If someone dies owning a bank account that has funds who do not pass to another person under the terms of an account. So if it has a beneficiary, this isn't going to work. But if it doesn't have a beneficiary, an interested person can apply to the court for an order requiring the financial institution to reveal the balance in the account if 90 days have passed since they died. So you have to wait to use this, but if you're pretty sure that there's no beneficiary, you can use this. You can only do this if letters have not been issued or no petition to appoint an executor administrator has been filed. This is from 2015, so it's fairly new. Oh my God, 9 years ago. It'll help, in my mind, it helps heirs determine what the appropriate next steps are. I can't tell you how often I'm talking to a client and I'm like, God, I wish I just knew how much money was there. Because you don't know if it falls under a small estate affidavit. You don't know if it's worth the retainer you're about to ask them for to go deal with all of this. But this would be in a special situation where the only thing you're dealing with, or you've got it narrowed down and this one account is the thing that's kind of the decision maker. But if there's other factors that point to, look, we need to do an independent administration anyway, then this would be, I don't know that this would be super helpful other than to just gather information. And then back to the determination of heirship, you've got to understand who gets what. This is called intestate succession. As you know, if someone dies without a will, the state of Texas has a will for them. The laws of intestacy dictate what heirs will receive specific types of property owned by the decedent, meaning we have to know if it's real property or personal property, if it's community property or separate property. There is, I'm sure you've all seen this handy dandy intestacy chart that's floating around. Sorry, technical difficulties on my, let's see here. Sorry, that did not work the way I wanted it to. Let me put it this way. If you Google Texas intestacy chart, you'll be able to find it. It's got pie charts all over it. The one that this was supposed to be linked to that doesn't work anymore was to Collin County. I've seen them linked in Harris County. If you can't find it, email me, jack@jackwilburn.com. I'll send you one. But it's just a really handy chart that shows you, okay, if there's a surviving spouse and there are kids of the marriage, who gets the community property and who gets the separate property. If there is a surviving spouse, but there are kids not of the marriage, then that changes who gets what. But it's just important for you to know who gets what while you're drafting your application for determination of heirship, because you need to lay out who gets what. Oh, there it is. Look at me. Hopefully you've seen this before. If not, it's really handy. Sorry, I'm having just all sorts of technical difficulties today. But, I use this every day. It's always good to refresh your memory. And especially when you get down to the no surviving spouse, no kids, a parent's alive, but a sibling's alive, that gets a little funky. So it's just a good chart to have. And then just in case you've never come across this little slice of heaven, the moieties, I'm just going to ruin your day with this. This happens more than I wish it did. People die, they're not married, they don't have kids, they don't have siblings that are alive, and their parents are dead. Well, then you have to split their estate into what are called moieties, and you have a paternal moiety and a maternal moiety, and you go up the family tree and out the family tree until you find a living relative, and then you go from there. But unfortunately, what moieties a lot of times ends up doing is, let's say somebody dies and they've got $1 million. Well, you split it in half, that's $500,000 each. On the maternal side, you'll find 87 heirs and they'll split that $500,000. And then on the other side, there'll be like two. And so you end up in this weird situation where somebody has the same level of relationship. You're both, second cousins twice removed, but because your side of the family has all died off, you get a lot more money than the other side that everybody's still living. It's just an interesting part of intestacy that it doesn't come up a lot, but just be aware that when someone dies, no wife or no spouse, no kids, no siblings, no parents, you're splitting it into moieties. And then as you do your heirship ownership percentages, it is always this percentage of half, not this percentage of the whole. So it's just something to keep your eye on. Let's see, that's the end of our presentation. Let me see what people are saying or questioning or correcting. Let's see, can you do an affidavit of heirship, title a company approves and drafted it, and after the house sells, you find assets that are going to require administration? Can you then file an independent administration and start an administration? You can, because not every asset can be dealt with via an affidavit of heirship. But it sure would help if they have the same facts, meaning that the heirs don't change between one and the other. Sorry, I was looking at the next thing. Is there a form for TEC 153? I'm not sure. I don't have a form for 153. I'm sorry. There may be one in the form books. I don't even know if there's one. The Dallas County probate section has their form book, which I used to participate in a couple of years ago. I don't remember that form being in there, so I'm sorry. But I would say back to the question about a subsequent independent administration after an affidavit of heirship. I've seen that before. It happens sometimes. As long as all the heirs are the same, I don't think you have an issue. If there is an issue, I think that's on the title company that relied on the affidavit of heirship, which is probably why some lawyers hate affidavits of heirship, because they don't have the certainty of a determination of heirship. That's why they say they're not worth the paper they're written on. So let's see, any other questions I can answer? Let's see. What if a man dies without a will and he's got a wife and a disabled adult daughter and a bio son and a stepson? What rights does the stepson have? So if you mean true stepson, meaning no adoption by estoppel, it's just an adult child of a spouse, that for the most part, steps have no inheritance rights, unless they could somehow make an argument for adoption by estoppel. but I would say the stepson doesn't have any rights. Does the executor have an obligation to share the contents of the will with a potential heir? Well, first, you, especially when they are not known for years. Well, so let's see. The best way to answer that is if you file a will, so, you know, we're here talking about intestacy, no wills, but if you have a will and that will's admitted to probate, the estates code requires that you send a copy of that will to everyone who's named in that will. So you do have an obligation to share it with an heir. You don't have to pre-share it. You only have to share it once the will's admitted. So let's see. Yeah, you don't have to share it prior to filing. If you've been practicing long enough that you know who Judge Wendell in Denton County is, he used to have this rule that you had to send a copy of the will to the beneficiaries under the will and the intestate heirs before you could probate a will. And that is what I just called the let's invite a will contest clause, but that changed after he left the bench in 2010. So, but since then I'm not aware of anybody that requires you to give prior notice of a will. Hey, it looks like I'm being told to shut up because it's almost 1 o'clock. If you look under the chat for part of the Zoom, Maricela is giving you the course number. If you can't see it, it's 174222332. And I believe this is an hour, and I don't know that it has any ethics attached to it. If it doesn't, I apologize because I know everybody covets ethics. So, but that is our time on intestacy. Hopefully you feel a little more prepared for the next time a client comes in and 70% of the time tells you they don't have a will. Let's just keep having people sign wills because it makes life easier. But I appreciate you taking the time to watch this. And let me give a plug for DVAP. If you have any opportunity to take a DVAP case, you will not regret it. If you don't feel comfortable with the area of probate, there are mentor attorneys that you will be assigned that will help you with your questions and answer the questions you have about what you're dealing with your client. So, oh, there you are. Sorry, I was still on shared screen. I couldn't see anything.
No worries. Thank you, Jack,
thank you
for a
listening,
wonderful
everyone.
presentation, cracking up and behind the scenes. But as Jack mentioned, the CLE is in the chat. It is 174222332. And that will also be emailed to all the attendees along with a copy of the slides. If you're interested in getting a copy of today's recording, please feel free to reach out to me separately and I can get that to you. Again, thank you for logging in for the first CLE of the year. We hope that you join us for the next one. And again, thank you, Jack. We hope you all have a good rest of your afternoon. Bye, everyone.
Thanks, everyone.
Thank you.
Thank you, Maricela.
Great.
Thank you, Catherine.